The next case is City of Akron versus Ohio Department of Job and Family Services. Good morning. Each side will have 15 minutes to present the arguments to the court, and the appellant may reserve up to 5 minutes. Just let me know, please, if you want to reserve time.
Thank you. May it please the court, my name is Tammy Quayle. I'm Assistant Director of Law with the City of Akron. My co-counsel is Ellen Nish from the City of Akron, and I would like to reserve 5 minutes for rebuttal. The city requests that this court reverse or vacate the hearing officer and commission's decision regarding an unemployment decision involving a City of Akron employee, John R. Gardner. It's clear in the record that Mr. Gardner was a City of Akron employee throughout all times pertinent in this appeal. And in this appeal, the court looks back at the hearing officer and commission's decision rather than reviewing the trial court order. In this case, the city is asking that the court find that the decision that's being appealed was unlawful, unreasonable, or against the manifest weight of the evidence. And primarily, the city is asking the court to look at a very narrow exception, which is common law waiver. Common law waiver applies in unemployment cases where the employee was represented by a union and the employment action in question was negotiated by the union in an arm's length transaction with the employer. In this case, Mr. Gardner suffered an off-duty injury pursuant to a transitional work program that was negotiated between the city and Mr. Gardner's union, the Akron Firefighters Association, Local 330, AFL-CIO. This program allowed employees who have been injured, whether it's on duty or off duty, to come back to work in a light duty position. The policy had negotiated timelines which could be extended and which were in Mr. Gardner's case. Mr. Gardner was afforded the opportunity through this union negotiated program to work extended light duty. His condition didn't improve, and so for a period of time he was taken off the light duty, but pursuant to the negotiated agreement, he was able to return to work in light duty once he applied for a disability retirement. And that period of time was another 180 days. So Mr. Gardner's disability retirement was ultimately turned down, but he worked the full 180 days under the transitional work program. When that time period was up, he was able to utilize all his union negotiated benefits that he had, which included sick leave, vacation leave, banked leaves, and ultimately, he ended up using up all those union negotiated benefits, but continued to have other union negotiated benefits, such as health care, when he entered a period of sick leave without pay. Now,
Excuse me, could that go on indefinitely?
that's a good question. And under the policy, the city was required when an employee wasn't making any medical progress to engage in the Americans with Disabilities Act or ADA accommodation process. And that's found in Section H, subsection 4 of the Transitional Work Program. So pursuant to the union negotiated policy, at the point where the employee wasn't progressing and it didn't appear that he could return to his regular job, the city engaged in the ADA process with Mr. Gardner as required by policy and as required by law. During this time, he was in the sick leave without pay, predominantly. And so that would have continued on as long as the process was going on. Generally, the ADA process goes faster than it did in this case. In this case, there were a lot of delays with Mr. Gardner in turning in his medical slips, or the first time the city tried to accommodate him, he failed a typing test. And then per the mayor's directive, the city's Personnel Labor Relations Director negotiated an agreement with the union to allow Mr. Gardner to get his typing skills up to par while he was already in the position.
Well, I'm a little confused. I thought that the city had notified him that they were going to terminate him and they were starting the process.
Yes, that's at the point that the mayor said, you know, look, he's close to retirement, let's bring him to the safety communications position, and he can bring his typing up to par at that time.
No, I mean, I'm sorry, I'm misunderstanding. Maybe I'm not getting my point across. You had indicated that he's doing all these, that he's trying to take the typing test, that he's exhausted all of his leave under the collective bargaining agreement, that you've given him all his federal and state due, and he's on sick leave without pay. And then he had tried for this position and he failed the typing test. And I thought in that time period, the city had notified him that he will be terminated.
You are correct, Your Honor, I'm sorry, I sort of skipped over that.
Well, I think that's kind of important, isn't it?
It is, it's very important to where we are. At the point where Mr. Gardner failed the typing test, the city moved to medically separate him. And pursuant to the
What
city's
does
charter.
medically separate mean? Does that mean you're fired?
Essentially, yes.
And there was a medical report that said he could never improve, he couldn't perform a multitude of physical activities.
That's correct, yes. So the city has a mayor's hearing under our charter, and at that point, when the mayor met with Mr. Gardner, he said, go ahead and accommodate him if you can work it out with the union, and we'll give him the ability to get his typing up to speed while he's in the position. This was an employee who was very close to retirement, and the mayor wanted to afford him the opportunity.
What did he do to demonstrate that he was bringing his typing up to speed, or did events overtake that?
The events overtook it as far as this case goes.
Okay.
It's not in the record, but he did go to the safety communications position. He was afforded that opportunity. But as far as this case goes, the period of unemployment ended when he accepted and started in the safety communications technician position, which was on December 24th, 2012.
The period of what?
The period of unemployment, which is in question here, ended on December 24th, 2012, which was Mr. Gardner's first day of employment as a safety communications technician.
So he was never, the process, he was notified that he was going to be fired, but he never got notice that he was actually discharged from employment.
Correct.
And so he was never technically discharged.
That's correct.
So why isn't that just in limbo as Appley is indicating and unable to work or no work at all?
That's a great question. And the hearing officer, in fact, in this case, found that that Mr. Gardner was, in fact, separated from employment. And this court is bound by the factual findings of the hearing officer. And at least as far as that finding, the city understands where the hearing officer came from with that, because that goes into the common law waiver argument. The hearing officer found that in his reasoning section, the claimant exhausted all light-duty work available to him under the union contract. And then he went on to find that Gardner was separated from work and that it was due to lack of work. So with the hearing officer's determination that the claimant had exhausted all light-duty work available to him under the union contract, that fully meets the requirements of the common law waiver exception to the granting of unemployment benefits. This was a right that Mr. Gardner had pursuant to the union negotiated contract. This is different from the cases cited in Appellee's brief in many ways. A lot of the cases that are cited have to do with agreements that were negotiated between individuals and their employer. This is also different from cases where an arbitrator found that there was just cause for discharge. the city's argument here on the common law waiver is this wasn't between Mr. Gardner and the city. This was between the city and the union, and those benefits went to the favor of Mr. Gardner. Mr. Gardner was able to have all these benefits of being a union employee and receiving taxpayer-funded benefits at the same time that he collected unemployment benefits. And the city's position is that that is unfair, it's unlawful, and unreasonable.
Okay, so what did he receive again?
He received unemployment compensation benefits for the period from 9/18/12 until December 24th, 12. At the same time, he had health care benefits, and he had the right to continued light-duty employment.
But there wasn't any.
Not at that point. But even his doctor, his chiropractor, Dr. Arnie, had said at that point that his medical restrictions were such that the light duty that he could possibly work would not be available. And Dr. Arnie did not limit that to his position as a firefighter or any other position. He just said that the light duty would be unavailable to work.
You are starting your rebuttal time.
Okay, thank you, Your Honor, I appreciate that.
Good morning. May it please the court. My name is Susan Sheffield. I'm the Assistant Attorney General representing the Ohio Department of Jobs and Family Services. Initially, I think it's important to keep in mind that this court has a very limited standard of review. As you are well aware, the court cannot rewrite the commission's decision even if you would have found differently. Unless the court finds that this decision is unlawful, unreasonable, or against the manifest weight of the evidence, you must affirm the review commission's decision. And because the commission's decision is supported by the record, you must affirm the decision. Now, just a couple of points that I'd like to make. The employer is arguing that this transitional work program caused Mr. Gardner to fall into the common law waiver to the exception of prohibition of unemployment compensation. The fact is that once his light duty ended, he used his own accrued time. When that was over, he was placed by the employer on what was termed unpaid sick leave. The employer's Exhibit B in the director's file is an absence report, printed out and termed so by the employer. He's listed as sick leave without pay. However, in the hearing that was held, the employer stated there's nothing in this CBA, the collective bargaining agreement, that would have placed this employee on a leave of absence. So they're trying to draw some fine line between unpaid sick leave and an approved leave of absence. Well, the transitional work program no longer existed for Mr. Gardner once he was placed on this unpaid sick leave because he was no longer in that program. How can this case fall under the Continental Airlines case where the woman, pursuant to the collective bargaining agreement, had to go on a leave of absence for her pregnancy at a specific time, whether she was unable to work or not? That's very different from a person who is unable to work, no longer is in a transitional work program as the employer defined it, and just out there in limbo. If the employer had separated Mr. Gardner for medical reasons, which is what was in the process, we would have had a very different case. Then we would be discussing whether it was a just cause discharge. That's not an issue here because he was never discharged. And by the way, if a person is discharged for medical reasons, it's not considered to be a just cause discharge. So we wouldn't even be having this discussion. So the employer notified him around, I think, July 30th that they were going to separate him. And during that time period in the fall, he met with the mayor. The mayor offered him this position without any typing requirement until he was in the job and he could train for that. The other issue that you have to look at, when you have, if you have this person who is on this unpaid sick leave, he meets the definition in the statute for total unemployment. Working, not working, okay, he's not working, and he receives no payment for working, for not working.
When you
Right.
say payment, you're speaking about salary.
I am.
Okay.
Now,
But
the employer today argues that the health insurance that he was provided is that remuneration. But there's nothing in the record that said he paid taxes on that. We pay taxes on remuneration, our income, okay? There's no record, nothing in the record that says he paid taxes on it. This is more like a worker in a factory or an auto plant that's laid off for a particular period of time. For instance, in an auto plant like Lordstown, they would have a changeover period of a couple weeks where they would change from one model year to another model year and the people are laid off. They're entitled to unemployment compensation during that time, unless some payment is made to them for holiday pay or something like that, but it would only be for the week where that payment is made. But other than that, they're entitled to unemployment compensation. This is more like that case. There is a case, and I was just looking at this last night. There's a case from 2013, the Ohio Supreme Court. It's called Bernard versus the Unemployment Compensation Review Commission. The citation is 136 Ohio State 3rd, 264.
And is this in your brief?
It is not. I just looked at this last night, and I would be happy to provide it after
Well,
as a supplemental authority.
our local rules say supplemental authority is only cases that are decided
Recently.
since the briefs were filed.
Well,
That doesn't mean that, the court will do its own research, but the point is, it's not really fair to the other side to allow you to
Sure.
argue things that they're not fair.
then I would argue specifically that Mr. Gardner was in an unpaid leave position. The employer can't have it both ways. They can't say that he was on unpaid leave of absence or unpaid leave, sick leave, which is what the documentation shows, and then to say, well, he's not in an unpaid leave, he was never in an approved leave of absence. They can't have it both ways. How do you do that? He's in limbo. Therefore, he is totally unemployed under this statute, and it meets the definition of totally unemployed, and he's entitled to unemployment compensation benefits. There is nothing in the record which shows that he paid taxes, and it was never even brought up that he paid taxes on this health care benefit. There's nothing in the record, and the employer can't argue otherwise. And I would ask that the court affirm the decision, because the decision made by the hearing officer and the review commission is supported by the record.
before you take your seat,
Yes,
Counsel,
ma'am.
there was a reference in the city's brief about your client, not your client, but about Mr. Gardner filing or something. And I just don't recall it specifically, but that he made a representation that he was not a member of the union.
Well,
Can you
once,
speak to that? Because that confused me.
yeah, I suspect, and I can't prove this because there's nothing, it wasn't brought up to him at the hearing, and therefore the argument was waived in my position. You have to bring these issues up during the hearing if you have some objection to something that's in the record. And if you don't, it's gone. Your ability to object to it is gone. But I think it has to do with his limbo status, that he's no longer an active member, he's not paying dues, during that time period. At least there's nothing in the record that says he was paying dues at that time period.
I think that Judge Moore may also be referring to the question that he filed for unemployment benefits claiming he had been discharged due to an accident at work. Now, maybe I misread something in the briefs and don't understand the circumstances.
Well-
That went along with the claim that he was not in the union.
Well, my understanding of this whole situation is that he was injured and could no longer do his job. One of the things that the employer argued in its brief is that he's not able to do his work that they've hired him for, and therefore he should not get unemployment compensation. Well, that goes along with he's unable to do the work that he was hired for, and therefore he can't work. It's due to his inability to do the work that they've asked, due to lack of work.
In fact, it wouldn't make a difference where he was injured.
No,
Whether he was at work
I
or
don't
not.
believe so, Your Honor, because you can't, an employer can't fire someone, separate them from employment for medical reasons, period. Now, Mr. Gardner, of course, is a layperson and certainly doesn't understand some of the complications and things that go along with this kind of law. But if the employer had discharged him for medical reasons, we would be arguing it was not a just cause discharge. There was no discharge. He did not quit. In fact, the employer in one of the briefs, and I can't remember whether it was at the trial court or at this court, argued that, in fact, he should have quit and gone to work someplace else. How do you have it both ways? You can't. Simply put, he was in a status where he was not getting paid, he was not working, he was in limbo. Therefore, the hearing officer found that he was separated due to lack of work. The law says total unemployment, you don't get paid for work that you're doing. He wasn't working, he wasn't getting paid. There's no evidence that he paid any taxes on any health insurance that he may have received during that time. And the question was never asked during the hearing. In fact, one of the arguments that the employer had in their brief is that, well, it took too long. He took 3 weeks or thereabouts to take this job, and therefore that time period between November and December, he shouldn't even be getting benefits for that time. Well, the fact is that on page 39 of the transcript, Mr. Gardner said that it took so long because he was waiting for a new contract from the employer because he wasn't going to start a job where he didn't know what the terms were. That's reasonable. He also had to get confirmation from his doctor that he was still able to work a light-duty job. On October 1st, when he applied for benefits, and this was asked during the hearing, on October 1st, when he applied for benefits, was he eligible to work based on medical certification? The answer was yes. His doctor said you can do light-duty work with these restrictions. You can work, but you have restrictions. He couldn't be a firefighter anymore. He couldn't climb up ladders and that sort of thing. But that's neither here nor there. He was able to work when he applied for benefits. He was not working. He was not being paid money for working, and the employer had not fired him. He had not quit. He meets the total unemployment definition under the statute of Revised Code 4141.01M, and that's what this is based on. If you have no further questions, thank you, Your Honors.
Thank you.
The city has several points that I would like to rebut from the appellee's argument. First of all, in the director's file is an application summary. It's at the beginning of the file in the record in Part A. And under question 6 in the application summary, under union, it says none of these / not in a union. Also, to point out on this page, when claimant was asked his reason for separation, he said he was discharged, and he said the reason why was an accident at work.
So your point is those two items go to Mr. Gardner's credibility?
Which I know the court can't look at this point, but there were questions about the file, and about whether or not he had stated that he was not a union member, and I just wanted to clarify that on behalf of the city.
But in terms of the legal analysis,
Right, it's just to clarify, he is
Okay.
a union member, and in fact, he was questioned at the hearing about his union membership, and he did state under oath that he is a union member, and he was a member of the firefighters union at the times relevant to his application. Now, during Appellee's argument, they stated that at the time that he was on sick leave without pay, that was not covered by any negotiated agreement. The city disagrees with that statement. The transitional work policy, which is Exhibit C to the city's initial appeal, which is in the record A, has in it the language I referred to earlier in Section H, and it's subsection 4, and it says, in those cases where the participant is medically unable to perform regular job duties due to permanent disability, the Return to Work Coordinator will make a referral to the Americans with Disabilities Act ADA Coordinator. In other words, had the city not gone through the ADA accommodation process pursuant to this policy, it would have been grievable and the union could have sought redress. So this period of time when the city engaged in the ADA interactive process was absolutely covered by the policy that's negotiated between the union and the city. And also, in the hearing officer's decision, the hearing officer very clearly found that the claimant had exhausted the light duty work which was available to him under the union contract. Now, the initial issue that the city had appealed was that the unemployment compensation, both the initial determination and throughout the appeals with the hearing officer, the issue going into the hearing was whether he was on a leave of absence. The city has very specific definitions about what a leave of absence is. There is a difference between unpaid sick leave and a leave of absence. Unpaid sick leave, at any time that you can get a return to work slip, you can come back to work. A paid or a leave of absence is an unpaid period, for military leave or something of that nature. So the city had appealed, and you'll see in the record, the issue of this being an unpaid leave of absence. And clearly the hearing officer moved away from that issue and in fact decided the lack of work issue, which was not the initial issue in the hearing. Okay. So when the city asked for reconsideration of the hearing officer's decision, it was in fact on the lack of work issue at that point, because the hearing officer had said, essentially by not deciding the leave of absence issue, that wasn't the issue here. And even Mr. Gardner replied to that. He even stated at the hearing that he didn't know where this leave of absence issue had came from.
And I'm sorry to tell you that you are out of time.
Okay. Thank you for your time and
Thank you.
consideration.
Thank you very much. The court will take the matter under advisement and a written opinion will be sent to both sides, as well as you can all look on the Ohio Supreme Court website and our 9th District Court of Appeals website where we use this. Thank you.